Come stand beside your car so we can write the ticket.
I am inside the house.
You were stopped.
Obstructing
You are now
what exactly? It's only a speeding citation. Work with me and leave, or you will be jailed.
Hey, phone my attorney. That's enough. You are now under arrest.
At precisely 10:30 a.m. on January 15th, 2024, inside a peaceful suburban area in Ridgewood, Sergeant Andrew Taylor made a choice that would destroy his career. He crossed a boundary both physically and legally. He stepped into a private residence without a warrant, without emergency conditions, and without any lawful authority at all. And the person he attempted to arrest, former Deputy Sheriff Elijah Morrison, who had spent 8 years enforcing laws before he witnessed enough corruption to leave the job. Before we explain what unfolded, if you value stories about people who refuse to allow badges to become tools for oppression, please consider subscribing. This situation became a clear example of why the Fourth Amendment is important, why police accountability matters, and why certain officers believe rules do not apply to them. Leave a comment and tell me where you are watching from, because this story spread online for all the correct reasons. Elijah Morrison had served as a deputy with the Ridgewood County Sheriff's Department for 8 years. Not simply any deputy, he had received 2 commendations for de-escalation, worked with community outreach programs, and maintained one of the cleanest service histories in the agency. But during 2023, he saw something that changed his entire outlook. 3 fellow deputies had assaulted a handcuffed suspect in the detention area. Elijah reported the misconduct. The deputies claimed the suspect had been aggressive. The body cameras had conveniently failed. Internal Affairs said there was not enough proof. 6 months later, Elijah resigned. He refused to work inside a system that protected officers who broke the oath he promised to honor. He returned to school, earned his paralegal certification, and began employment at a civil rights law practice. He spent his days helping victims submit complaints against the same department he once worked for. Some previous co-workers supported him. Many hated him because of it. Sergeant Andrew Taylor belonged to that second group. Andrew Taylor had served in law enforcement for 19 years. He had worked alongside Elijah briefly before the resignation. And when Elijah submitted that misconduct report about the assault, Andrew Taylor had been one of the closest associates of those 3 officers. He testified during the internal investigation supporting their version of events. He called Elijah dishonest, disloyal, someone who did not understand real police work. So, when Andrew Taylor was performing traffic patrol that December afternoon and checked a license plate that returned Elijah Morrison, something changed in his attitude. The vehicle, a 2022 Toyota Camry, had been traveling 43 in a 35 zone, 8 miles over. The type of small violation that normally earns a warning, maybe a citation if the officer feels irritated. Andrew Taylor felt worse than irritated. He followed Elijah for 6 blocks, watching him use signals correctly, stop fully at stop signs, and keep proper lane control. Perfect driving except for the earlier speed. When Elijah turned into his driveway at 10:25 a.m., Andrew Taylor turned in directly behind him, preventing him from leaving. Elijah stepped out of his car. He was 34 years old, 6 feet 2 inches, black, and the second he saw Andrew Taylor's expression, he understood this was not about speeding. "Afternoon, Sergeant," Elijah said, keeping his voice level. Andrew Taylor ignored the greeting. "License and registration." Elijah handed them over. "What is the reason for the stop?" "Speeding 43 in a 35. "Understood. Are you writing me a ticket?" Andrew Taylor stared at the license for an extended time. "Too extended." "Morrison, you still doing that paralegal job? Helping criminals sue officers?" "I help citizens file civil rights complaints when rights are violated. It is lawful work. It is betrayal. Have you ever experienced someone in power misuse authority because of a personal grudge? Tell me in the comments, because what happens next shows exactly why we need accountability systems that actually function even when officers resist them. Elijah sensed the tension increasing. He had training in this. He recognized the warning signs. Andrew Taylor's jaw was clenched. His shoulders looked rigid. His hand kept drifting toward his belt. Not toward his weapon, but toward his handcuffs. This was no longer only a traffic stop. This was something different. "Sergeant Andrew Taylor," Elijah said carefully. "I am going to step inside my house now. You can place the ticket on my windshield or mail it. Have a good afternoon." He turned toward his front entrance. His fiancée Sarah could be seen through the window observing. She had heard stories about Andrew Taylor. Elijah had told her about the tension, the past conflict, and the reason he quit the department. "Stop right there," Andrew Taylor shouted. "You are not dismissed." Elijah paused on his front steps. This was his property, his driveway, his residence. Sergeant, I gave you my license and registration. I am cooperating with the traffic stop. Unless you are detaining me for something beyond speeding, I am going inside. I said stop. Elijah turned back. Am I being detained? You were speeding. I am investigating. Investigating speeding? It is either confirmed on radar or not. What is there to investigate? Andrew Taylor's face looked tight. Two neighbors had stepped outside onto their porches. Mrs. Chun from 3 houses down. Mr. Patterson across the street. Both had phones out. Both were filming. Elijah noticed them. Andrew Taylor noticed them. Stand next to your vehicle, Andrew Taylor commanded. For what reason? So I can write the citation. You can write it without me remaining outside. I gave you my documents. I am going inside my home now. Elijah walked up his 3 front steps. He opened the door. He was stepping into his home when Andrew Taylor's voice cut through sharply and aggressively. Come stand by your vehicle, so we can issue the citation. Elijah was halfway inside. Sarah stood beside him, her hand gripping his arm. He could sense her tension, see fear in her eyes. She knew the stories. She knew what Andrew Taylor might do. But Elijah also understood his rights. He knew precisely what was lawful and unlawful. I am in my home, he called back, calm but firm. You can write it without me coming outside. Andrew Taylor moved 2 steps closer to the porch. You were detained. Refusal to comply is obstruction. And there it was, the false claim officers use when they want escalation. The fake authority statement designed to force compliance through fear instead of law. Elijah had never been told he was detained. He had never been given a lawful command to remain. The exact words, "You are being detained," were never spoken. And even if they had been, once he gave his license and registration, the traffic stop was essentially finished. There is no law requiring someone to stand beside their vehicle while a ticket is written. There is no law requiring someone to wait on their own property while an officer completes paperwork. Elijah understood this. He had written nearly 300 traffic citations during his 8 years as a deputy. He attended the same training Andrew Taylor attended. He studied the same legal cases. He knew Rodriguez versus United States, the Supreme Court ruling stating officers cannot extend traffic stops beyond the time needed to handle the original violation. He understood the law better than Andrew Taylor apparently did, or at least better than Andrew Taylor chose to follow. Obstructing what? Elijah said, still standing inside his doorway. His voice carried across the yard. Mrs. Chen's phone camera recorded everything. It is a speeding ticket. I gave you my license and registration. I have not interfered with your ability to write a citation. What exact action of mine is obstruction? Andrew Taylor stood at the bottom of the steps. His hand rested on his radio. His other hand hovered near his belt. Do not play lawyer with me, Morrison. You know exactly what you are doing. I am exercising my constitutional right to be inside my home. That is what I am doing. Last chance. Cooperate and leave or go to jail. Leave. Andrew Taylor had just ordered Elijah to leave his own home. The absurdity would have been humorous if it were not so dangerous. This was classic retaliation, classic authority abuse, and it was all being filmed from 3 different viewpoints. Sarah's grip tightened around Elijah's arm. She whispered urgently and frightened, "Call someone." Elijah briefly turned his head toward the interior of the house. "Babe, call my lawyer." That is when Andrew Taylor lost control. "That is it. You are under arrest." The officer stepped forward into the doorway. Sarah held her phone recording. Mrs. Chun recorded from her porch. Mr. Patterson recorded across the street. And the camera shakes as the officer grabs Elijah and forces him downward, trying to put him on the ground inside the house. "You have no right to enter my home," Elijah said, voice strained, barely audible as Andrew Taylor grabbed his collar. Sarah, off camera, crying, "You cannot do that. You cannot come inside." But Andrew Taylor was already inside. He crossed the threshold of a private residence without a warrant, without probable cause, without emergency circumstances, and without lawful authority. In anger, in his need to dominate the man he saw as disloyal, he violated one of the most basic principles in American law. The home is protected. The 4th Amendment makes that clear. Officers cannot enter without a warrant or without an emergency. Traffic violations do not create emergencies. Hurt pride does not create probable cause. And personal grudges do not override constitutional rights. Elijah did not resist. He was trained in force protocol. He understood that fighting back, even to protect his own home, would give Andrew Taylor justification. So he allowed himself to be forced onto his own living room floor. His cheek pressed against the hardwood floor. He and Sarah refinished themselves last summer, while Sarah screamed, cried, and continued filming. "Stop resisting," Andrew Taylor yelled, even though Elijah was not resisting. It is an old tactic. Shout, "Stop resisting," to create audio evidence that justifies force, regardless of actual resistance. Elijah had seen officers do it before. He reported it while still working there, and now it was happening to him inside his own home over a speeding ticket. "You are making this worse," Andrew Taylor grunted, forcing Elijah's hands behind his back. "I am not resisting," Elijah said clearly loud enough for cameras. His voice stayed steady despite pressure on his back, despite the knee Andrew Taylor pressed between his shoulder blades. "I have not resisted. You entered my home without a warrant. You violated my Fourth Amendment rights. This arrest is unlawful." Every word was intentional. Every statement created a record. Because Elijah knew something Andrew Taylor forgot in anger. This would not end here. This would go to court. This would be reviewed. And every word, every action, every violation would be examined. Andrew Taylor tightened the cuffs too tightly, intentionally. "You are under arrest for obstruction and resisting." "I never resisted." "Sarah, make sure you are recording this." "Mrs. Chen, are you filming from the doorway?" Mrs. Chen's voice. "I captured everything. Every second." Andrew Taylor yanked Elijah to his feet. Elijah was 6 feet 2 inches and weighed 30 pounds more than Andrew Taylor, but he moved like a rag doll, offering zero resistance, making sure witnesses saw he complied physically while asserting rights verbally. "This is an illegal arrest," Elijah said again. "You entered my home without legal authority. You are violating clearly established Fourth Amendment protections." Payton v. New York, 1980. Police cannot enter a residence to arrest without a warrant unless emergencies exist. There were no emergencies. This is unlawful. Do you believe officers should face criminal charges when they knowingly violate constitutional rights? Share your thoughts in comments, because what happened to Sergeant Andrew Taylor shows exactly why qualified immunity needs major reform. Andrew Taylor escorted Elijah out of his residence, down his front steps, past his own vehicle, toward the police cruiser. Sarah was speaking with an attorney on the phone. Mrs. Chen continued recording. Mr. Patterson had crossed the street, holding his phone out, capturing every detail. "You all see this?" Mr. Patterson shouted. "Officer just walked into this man's house. No warrant, nothing." Andrew Taylor ignored him. He placed Elijah in the back of the patrol vehicle, slamming the door hard enough that it bounced open and needed to be shut again. Then Andrew Taylor stood there breathing heavily, realizing what he had done. It was visible on his face. The moment adrenaline began fading and legal reality started setting in, he had entered a home without a warrant on camera with several witnesses. Over a speeding ticket, he keyed his radio. "Dispatch, mark me 1015 with 1 detained. Obstruction and resisting arrest." Dispatch 104. What was the original violation? Pause. Too long of a pause. Traffic violation. Copy. Transport to county. Another pause. Andrew Taylor looked at the neighbors, looked at their phones, looked at Sarah standing in the doorway of her house, tears running down her face, her phone still recording. 104, Andrew Taylor finally said, but he did not move. He stood beside his patrol vehicle for 45 seconds, just standing there, and you could almost see him trying to figure out how to undo what he had done. He could not. There is no undo button for constitutional violations. Elijah sat in the back of the patrol car, handcuffed too tightly, and he remained silent. He did not need to speak. The cameras had already spoken. The drive to Ridgewood County Jail lasted 18 minutes. Andrew Taylor did not speak once during the drive. During booking, Elijah was processed for obstruction of official duty and resisting arrest. The booking officer asked about the situation. Subject refused to comply with lawful orders during a traffic stop, Andrew Taylor said. The booking officer looked toward Elijah. "You want to explain your side?" "I was inside my home. I had provided my license and registration. The officer entered my residence without a warrant and without legal authority. Multiple witnesses recorded the entire event." The booking officer's pen paused. "He entered your house?" "Yes. For a traffic stop, for an 8-mile overspeeding ticket." The booking officer looked toward Andrew Taylor. Andrew Taylor's jaw remained tight. His arms were crossed. He was obstructing. By entering his own house. He was detained. Was he told he was detained? Silence. The booking officer sighed and finished the paperwork. Elijah was placed inside a holding cell. His lawyer, Marcus Webb, arrived 90 minutes later. Marcus had been a defense attorney for 23 years. He had witnessed many cases, but when he listened to Elijah's story and watched the videos that Sarah and Mrs. Chun had already uploaded to a secure drive, his expression changed from concern to disbelief to controlled anger. "He entered your home," Marcus said slowly, "without a warrant during a traffic stop and arrested you inside your residence." "Yes. And you never resisted." "Never. I verbally asserted my rights. I never physically resisted." Marcus closed his laptop. "Elijah, I have practiced law for over 2 decades. This is the clearest Fourth Amendment violation I have ever seen. Peyton v. New York is 44 years old. It is established law. Every police officer in America knows you cannot enter a home to make an arrest without a warrant unless there is an emergency. A speeding violation is not an emergency. This will end Andrew Taylor's career." "Good," Elijah said quietly. By 8 p.m. that evening, Marcus secured Elijah's release. The obstruction and resisting charges were still technically active, but the prosecutor who reviewed the arrest report and watched the videos told Marcus privately that those charges would not survive past the preliminary hearing. By 10 p.m., Sarah had uploaded the complete video to Twitter, Facebook, and Instagram. She tagged the Ridgewood Police Department, the Ridgewood County Sheriff's Office, the ACLU, and every local news station. She also sent copies to the local newspaper, to 3 different civil rights organizations, and to a professor at Ridgewood State University who taught constitutional law. The caption was simple: "Former deputy arrested in his own home over speeding ticket. Officer enters without warrant." This is what retaliation looks like. The video received 37,000 views in the first hour. By morning, it had 1.8 million views. By that afternoon, every major regional news outlet had covered it. By the weekend, it was national news. The comment section became a space for shared experiences. Hundreds, then thousands of people shared their own stories of police overreach, warrantless searches, retaliatory arrests. A woman in Ridgewood described being detained for 40 minutes during a traffic stop while her toddler cried in the back seat only to be released with a warning. A military veteran described being pulled over 7 times in 3 months, always released without citation, always after mentioning his service. A college student described being arrested for disorderly conduct after asking an officer for his badge number. What Maria's video had done for border checkpoint awareness, Elijah's video was doing for residential Fourth Amendment protections. It documented in crystal clear footage with perfect audio the exact situation civil rights attorneys had tried proving for years. Officers allowing personal grudges to override professional duty. Retaliation disguised as policing. Constitutional violations carried out with confidence. And Andrew Taylor's decision to enter that home, that single decision, made in anger, recorded from 3 perspectives, had captured everything. The ACLU released a statement within 24 hours. The warrantless entry into Mr. Morrison's home represents a clear violation of the Fourth Amendment. The Supreme Court established in Peyton v. New York that law enforcement cannot enter a residence to make an arrest without a warrant, without emergency conditions. No such conditions existed here. We are prepared to support Mr. Morrison in any legal action he chooses to pursue. The Ridgewood County Sheriff's Office released their own statement. We are aware of the incident involving one of our officers and are conducting a full internal investigation. We take all misconduct allegations seriously. The type of statement that usually means nothing and promises little. But this time, pressure did not disappear. The videos were too clear. The violation was too obvious. And Elijah Morrison was not just another citizen unfamiliar with his rights. He was a former deputy who knew exactly what the law required and exactly what Andrew Taylor violated. On December 13th, 4 days after the arrest, Sergeant Andrew Taylor was placed on administrative leave. The internal investigation was assigned to a lieutenant from another district to avoid any suggestion of bias. The investigation lasted 6 weeks. During that time, Elijah's criminal charges were formally dismissed. The prosecutor's office released a statement. After reviewing all available evidence, we determined the charges against Mr. Morrison cannot be supported and are dismissed with prejudice. Dismissed with prejudice meaning they cannot be filed again, meaning the prosecutor reviewed evidence and concluded not only that the charges were weak, but that they never should have existed. The internal investigation findings were released on March 24th. They were devastating. The report was 43 pages long and left no room for interpretation. Sergeant Andrew Taylor violated department policy regarding warrantless residential entry. He violated Fourth Amendment protections established by clearly settled case law. He made false statements in his arrest report, claiming Elijah physically resisted when all video evidence showed otherwise. He failed to activate his body camera during the incident, violating department policy. And the investigation found evidence that personal hostility toward Elijah stemming from Elijah's previous internal affairs complaint motivated the arrest. The report documented specific violations in painful detail. Andrew Taylor followed Elijah's vehicle for 6 blocks before initiating the stop. Despite having clear view to read the license plate from the first block, he ran Elijah's information through the system twice. Once after the initial stop and again 4 minutes later, suggesting he searched for additional reasons to extend the stop. He spent 9 minutes at the scene before demanding Elijah exit his house, far longer than necessary to write a simple speeding citation. The investigation also reviewed Andrew Taylor's body camera history. In the previous 6 months, he deactivated his camera during 17 separate interactions. 14 of those interactions involved black residents of Ridgewood. None of those interactions resulted in disciplinary action before this incident. Most damaging, the investigation discovered text messages between Andrew Taylor and 2 other officers from the week before the incident. In those messages, Andrew Taylor complained about seeing that traitor Morrison around town and expressed hope he would get a chance to remind him what loyalty means. The report used the word retaliatory 3 times. It used unlawful 7 times. And it ended with a recommendation for termination and possible criminal charges for civil rights violations under color of law. On March 27, Sergeant Andrew Taylor was fired from the Ridgewood County Sheriff's Office after 19 years of service. The termination letter was 11 pages long. It listed every policy violation, every false report, and every piece of evidence proving he allowed personal grudges to override professional duty. Andrew Taylor appealed. His union defended him. They argued he made a judgment decision in a stressful moment, that Elijah had been argumentative, that officers need flexibility to maintain control. The arbitration hearing occurred on May 15. Marcus Webb attended, representing Elijah's interests. Though Elijah was not part of the employment dispute, Marcus brought the videos. He brought printed case law. He brought a timeline showing Andrew Taylor followed Elijah for 6 blocks before initiating the stop, suggesting planning. The arbitrator denied the appeal on December 3. The termination remained. But the story did not end there. On May 9, 2024, Elijah Morrison filed a federal civil rights lawsuit under 42 U.S.C. Section 1983 against Sergeant Andrew Taylor and the Ridgewood County Sheriff's Office. The lawsuit alleged Fourth Amendment violations, unlawful arrest, false imprisonment, and retaliatory conduct. The lawsuit was 137 pages long. It included video transcripts, expert testimony from a former police chief about correct arrest procedures, and depositions from neighbors who witnessed everything. It also included Elijah's earlier internal affairs complaint and evidence that Andrew Taylor had held hostility toward him for years. The complaint detailed 7 separate constitutional violations: warrantless entry into a residence, unlawful arrest without probable cause, false imprisonment, excessive force, retaliatory prosecution, violation of First Amendment rights for reporting misconduct, and a 14th Amendment equal protection claim based on selective enforcement. Each violation was supported by case law, expert analysis, and video evidence, leaving no room for doubt. The sheriff's office attempted settlement quickly. They knew what a jury would see. A former deputy arrested inside his own home over a speeding ticket by an officer with a known grudge. They knew about the text messages. They knew about the pattern of body camera deactivations. They knew Andrew Taylor's own training records showed he learned the exact Peyton v. New York standard he violated. They offered $75,000 within 2 weeks of filing. Marcus laughed and countered with $950,000. Negotiations lasted 6 weeks. The sheriff's office involved their insurance company. They hired outside legal counsel. They conducted mock jury presentations and returned terrified. Every mock jury awarded damages. The lowest award across 8 simulations was $420,000. The highest was $2.3 million. They settled July 18th for $750,000. The settlement included a formal apology from the sheriff's office, a commitment to improve training on Fourth Amendment protections and warrantless entry limits, and a requirement that all deputies complete de-escalation training focused on recognizing when personal emotions might affect professional judgment. It also included a clause that Andrew Taylor could never be rehired by any Ridgewood County law enforcement agency, and a requirement that the sheriff's office report the settlement and termination to the State Peace Officer Standards and Training Commission. Elijah donated $300,000 of the settlement to organizations providing legal representation to people who cannot afford attorneys in civil rights cases. He created a scholarship fund at Ridgewood State University for students pursuing civil rights law, and he funded a community education program teaching people their constitutional rights during police encounters. The real lesson here is simple. The Fourth Amendment matters. The home is protected, and badges do not grant immunity from constitutional law or basic human decency. Andrew Taylor believed his authority meant he could violate rights without consequence. He believed Elijah's past complaint made him a valid target for retaliation. He believed crossing that doorway was justified because his pride was hurt. He was wrong on every level. Andrew Taylor cannot work in law enforcement anymore. His certification was revoked. He attempted to get hired as a mall security guard, but the background check revealed the termination and federal lawsuit. The last update suggested he worked as a dispatcher for a towing company in a nearby city, still claiming he did nothing wrong. The Ridgewood County Sheriff's Office rewrote policies regarding residential entries. They now require supervisor approval for any warrantless entry unless clear emergency conditions exist. They review body camera footage quarterly for compliance, and they implemented a mandatory reporting system for any officer who has personal history with a subject they are about to encounter. Elijah's video has been viewed over 23 million times. It is used in police academies as an example of improper conduct. It is shown in law school classes covering Fourth Amendment protections. It is referenced in civil rights training seminars nationwide. And Elijah Morrison continues working at that civil rights law firm. He continues helping people file complaints against officers who violate their oath. He has consulted on 6 federal civil rights cases since his own. And he and Sarah married last spring in a ceremony attended by Mrs. Chun and Mr. Patterson, the neighbors who recorded everything and whose footage helped ensure justice happened. Because sometimes justice needs witnesses. Sometimes it needs cameras, and sometimes it needs someone who understands the law well enough to defend their rights, even when authority attempts to silence them. If this story impacted you, subscribe and share it with someone who needs to understand their rights. Leave a comment. Have you ever witnessed or experienced police overreach? What is one thing you learned from Elijah's story? The cameras stayed recording. The rights were defended. And one officer learned that personal grudges do not override the Constitution.